This is the plaintiff, Doug DeMasi. He says the defendant's a crooked attorney who did poor work for him, gave him bad advice, and he wants a refund for the monies he foolishly paid him up front. Lawyers are supposed to be honest and trustworthy, and the defendant is anything but, so he's here suing him for the return of his $2,875. This is the defendant, Francis O'Reilly. He says the plaintiff hired him to file for bankruptcy. He prepared all the necessary paperwork, put in many hours of research, and when the plaintiff discovered his son would be affected by the bankruptcy, he backed out. He's been an attorney for 30 years and has thick skin and refuses to return the money he earned for working for a client. He's accused of lawyering up.
All parties, please raise your right hand. Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
Doug DeMasi and Patty DeMasi, you have power of attorney for her. You're suing Francis O'Reilly, your lawyer, for $2,008, or your former lawyer, for $2,875 that you paid him because you say that he misrepresented to you what the effects of a bankruptcy would be on your son. Tell me what happened.
I got burnt, Your Honor. Patty got burnt, so I met Mr. O'Reilly.
What do you mean by burnt?
Well, I was supposed to get paid on a couple of jobs. I didn't get it, so it left us financially strapped, and we were thinking about going bankruptcy. And I met Mr. O'Reilly, and the first thing I said to him is, my son and I share a credit card. Will he be affected in any way? And Mr. O'Reilly said he wasn't sure. He was going to let me know, because no parent would ever involve their kids in their financial problems. No parent would.
And that's why, because you have one of your credit cards is with your son?
Yes.
Okay.
And
how much was the balance on that card?
I forget. I think it was right around $20-some thousand, something like that. But the point is I made it very clear that, is my son going to be affected? And Mr. O'Reilly said he wasn't sure. He was going to let me know later on. He told me it was going to be $2,875 for Patty and I. I said, all right, it'll take us a long time to save it up. We saved it up. We sent over some of the documents that Mr. O'Reilly wanted, including the check.
Did you ask him, when you say it'll take us a long time to save it up, how long did it take you?
It took us about 2 months, month
All
and a
right,
half
so
or
in
2
those
months.
2 months, did you say, do you have the answer to my question that I am insisting right now to know, which is, will this affect my son? Did you ask him that again?
Mr. O'Reilly said he was going to let me know.
No, I know, 2 months passed, so
Right.
now he can let you know. He couldn't let you know that minute, you're saying.
And he didn't let me know.
Okay, so before you hand him the check, do you say, before I hand you this check, it's been 2 months, did you get the answer to this simple legal question?
I mailed him the paperwork and the check. No, I didn't ask him.
Okay,
So,
now, let me hear from you a second. Hold on, I'll be back with you in a moment. So what is your version of how the, before the retaining of your services happens?
Your Honor, I met with Mr. DeMasi, initial client interview on April 17th, 2018. I don't recall that issue having been arisen at that time because it's quite obvious to any bankruptcy attorney that if there's a co-debtor on a card, that co-debtor would be responsible. And we see these all the time, Your Honor. The card was about $30,000, as I recall. The answer is very simple. If your son
And you would have given the answer had the question been asked?
Absolutely. And when Mr. DeMasi did finally come in and ask the question when we were getting ready to file the petition after I prepared
After you wrote the petition?
I explained to him that, yes, his son would be responsible for the amount that was due since
So
he was a
what
co-debtor.
you feel is that it occurred to him that, you know, and like a good dad, because he did then say, I don't want to, you know, I mean, it's obvious that this is something that he was concerned about, but he didn't think it through until he sees that it's going, and says, wait, my son's name is there. What's going to happen with that? Well, yes, it's going to affect him. That's where he decided, well, forget it then. I don't want to do bankruptcy?
Actually, he didn't decide it that day, Your Honor. I explained to him when he came in to file the petition. He said, wait a minute, I want to hold off. Let me go talk with my wife. He went and talked with his wife. My contemporaneous time records indicate that about 2 weeks later, on July 24th, he originally came in on July 6th to wrap up the petition, sign it, hadn't done his credit counseling yet. On July 24th, he called me and said he did not want to go forward with the filing of the petition.
How much did you charge him for the credit counseling that wasn't done?
I don't charge for credit counseling, Your Honor. They do that independently. It's a $10 fee per family, but I didn't charge that. Your Honor, there's no doubt whatsoever that there's $375 at this point due to Mr. DeMasi. That's a $335 filing fee and a $40 credit report.
Your Honor,
But I did prepare a bankruptcy petition, Your Honor.
Which means, tell me what goes into preparing the bankruptcy petition.
Well, thank you.
Listen.
Mr. DeMasi sent us his documents. We received them, I would say probably on May 11th.
And what are, quote, his documents?
Well, that would be any bills that he might have, automobile titles, pay advices, tax returns, documents that we require to prepare a bankruptcy petition. I then gave them to my paralegal, Ms. Posner, and Ms. Posner prepared a bankruptcy petition in telephone consultation with Mr. DeMasi. When we had it prepared as far as we could go, we had Mr. DeMasi come in so that we could finish what needed to be done. He also, by the way, Your Honor, executed a standard retainer agreement, and I'd like to have that marked for purposes of identification as Defendant's Exhibit A.
Where he agrees to pay $400 an hour, and then, I don't know, do you have the paralegal rate in there?
$200 an hour for the paralegal.
I
but-
know that's a paralegal, but is it in the retainer?
I believe it is, Your Honor.
I don't think it is.
Okay, well, in any event, it's a flat fee, and we have in the top of the second page, at the bottom of the paragraph, it states that the full amount is earned upon preparation of a Chapter 7 bankruptcy petition, because we've had people, rarely, but we've had people back out on occasion, and we've done a lot of
Not
work.
upon the filing, upon the preparation.
Preparation.
Correct. Okay,
Your
do
Honor?
you have what you signed?
I have what I signed, but Your Honor, the point is when Mr. O'Reilly finally called our home on the 3rd of July, he wanted to talk to Patty for a minute, then I talked to him, and I said, is my son going to be involved in my financial problems? Because we have a joint card. And Mr. O'Reilly finally said yes. And I said, stop everything, I want my refund back, period. And he goes, okay, no problem.
Why
I
don't you just
understand.
write that in the contract if that was such a big contingency? In other words, you're presented with a contract to sign, and if you expect your money back if your son's involved, why don't you just put a little
You
asterisk
know,
on it?
you're a judge and attorney. You think of all these things. I'm just an average blue-collar worker trying to survive.
I mean,
didn't think
I
about it.
usually have that feeling of what you just said, and I understand that. I'm still going to ask the question, though, because you seem like a really smart guy. And,
Oh,
and
I'm not that smart because I'm here, because if I was smart, I wouldn't be here. It's just that simple.
Okay, listen, I sympathize with everything that you're saying. I want you to explain to me, give me a way to get around the following statement that you signed in this contract. Should you decide to discontinue this matter at any time, you agree to sign a written statement to that effect and will be charged for all services performed up until such a statement is received by the firm. You agree to pay promptly any bill rendered for such services. You understand that our fee is fully earned upon the preparation of the petition. Tell me how to get around that sentence.
He never prepared anything.
Let me see the petition.
Never prepared anything. He
How do
never
you know he
mailed
never
us.
prepared anything?
He never prepared anything. He never mailed us anything.
Well, he never mailed us anything, you can say. He never prepared anything.
He never
Did you go to his office?
I went to his office twice for just a few minutes, and he never
I-
prepared any documents. He never mailed us any
Were
documents.
there, when you went to his office, did you look at any documents?
He didn't have any documents there. I didn't have any
Were the
documents
documents
there.
prepared on the day that he went there?
Oh, they were prepared well before that, yes, Your Honor.
They were prepared on what day?
Your Honor, we've been preparing them all along.
Yeah, no, they were finished on what day?
June 12th.
That's impossible,
Why is it impossible?
because he called us on July 3rd. He needed more information, more documentations. So he couldn't have prepared anything. I sent the paper.
Hold on. Stop. You just said that's impossible because he called us on July 3rd wanting more information. Show me proof that on July 3rd he was asking for information, and let me see what that request looked like so I can deem whether or not he's a liar about having the petition done in June.
Welcome back to the People's Court. Harvey Levin here. So if you hire me to do your bankruptcy and then all of a sudden you back out and say a month later, I don't want to do it, do you still have to pay me?
Absolutely. You committed to the job, you committed to the work, you have to pay the person.
But if I don't do the bankruptcy, it's kind of valueless, right?
No, I don't think so. Like, the person did the work, they should get paid for it.
But I don't get anything out of it because I changed my mind and I don't want a bankruptcy.
I still think the lawyer should get paid.
I should get paid. Boy, a crowd of lay people who are pro-lawyer. Amazing going inside the courtroom.
On my chain of events, it has the time and date that Mr. O'Reilly called me.
That's you writing it down. It's the same as you
That's
saying
right.
it here. Now I'm asking you for proof. You have phone records, you have texts, you have emails, you have anything like that. All right,
No,
got
I don't
it.
have the
All right,
cell phone.
I got it. According to your testimony, the first time he brings up his son is in your office or on the phone?
My recollection was in the office, Your Honor.
And that is on 7/6?
Correct, Your Honor.
And according to you, when do you hear from him that he does not want to involve his son?
Again, Your Honor, that would be 7/24.
What day did you give him the money?
On the 28th, I mailed it out
28th of what?
of May.
And tell me what you did from the 28th of May until July 24th. Were you giving him documentation and stuff?
Well, July 3rd is when he called me, when Mr. O'Reilly called me, and I told him then, cancel everything. I don't want to do anything. Just send back the retainer.
Do you have any proof of that?
July 3rd,
Yeah.
you should have brought my better half.
Well, you should have
Because
brought
Patty-
proof, though. Like
Excuse me?
your phone records would show stuff like that.
July 3rd, Monday is when Mr.
Are you looking
O'Reilly
at your
called
own
me.
notes again?
Yes, I
Yeah.
mean, you asked me, and that's what I'm saying to you.
Yeah, I know. Look,
So-
this is what we're left with. You signed a contract that said that once the petition is drafted, we have earned our fee. There's nothing about $400 an hour at that point. You want to argue about the petition having been drafted or not drafted and when it was drafted. They are showing me records that the thing was drafted by what date?
June 12th, Your Honor.
And then the very next meeting with you is on July 6th when you come in. And what was the purpose of him coming in?
Well, Your Honor, we were going to finalize what needed to be done for the filing. He needed to do his credit counseling, and we wanted to get the petition filed.
Right.
Excuse me.
He's welcome to come to my office and file this
He's
petition.
the one, he's suing you. He hates you.
Well, okay. I don't, but I love
I
him.
got it, I
Your
got it,
Honor.
I got it.
Your
Yeah.
Your Honor, Mr. O'Reilly repeatedly said I was at his office on July 6th. He repeatedly said that. That's an outright lie. I wasn't on July 6th. I'm 100% sure. In fact, I'm so sure, I'll take the money that he owes me, and I'll pay you and your deputy to go
Objection.
You
up.
know, the law doesn't look
Objection.
kindly on that kind of thing.
And I'll go up at the St. Dennis Church and swear in front of the priest. But the point is,
Yeah, hold on. I'm
I
mixing
never
stuff.
saw Mr. O'Reilly on July 6th because it would have been in my
Yeah,
notes.
I know. You're getting hung up on little things like that instead of the essence of the case. The essence of the case is whether or not a petition had in fact been drafted. Because the contract that you signed, not me, you signed a contract that said that the money is earned once the petition is drafted. So, you know, every time the man says something, he says, that's not true. Well, how do you know? Because I say it's not true. That is not, that's not helpful to me. You know, do you have any evidence outside of saying that's not true?
No matter what happens today, I
It's
will
fine.
be on record clearly saying that I would never hire Mr. O'Reilly because
Okay.
he's a liar and a crooked attorney.
Okay,
You
you've
can't
got
get
to
any-
say that, and now we're done, and now I'm going to rule, based on the contract that you signed, where you say that his fee is earned once the petition is drafted. Based on the records I have in front of me, which you cannot contradict in any way, shape, or form other than saying, he's a liar, that's not true, okay? Based on the fact that you were returned tons of documents, tons of them, that you have been sending in because they can't even prepare the petition unless you're sending those documents in, and you've paid the guy to do it, and the guy's doing it. I don't know that you can turn around and say, he didn't do anything when you've been handing him all these documents for all of that time. Of course he did something. You just decided at that point that you didn't want to go forward, and that's fine. You're a great father. But if even hiring him is contingent on the answer to that question at the beginning, then it's kind of weird that you handed the money and all the documents without insisting on the answer to the question. And the answer to the question is a very ready answer. It's a very ready answer. So even assuming he's a crook and he didn't want to give you the ready answer because you're the only guy declaring bankruptcy and he needs your money, all right? Even if that were to be the case, I'm kind of wondering why a guy as on the ball as you doesn't say, well, I've collected the money. It's been 2 months. What's the answer to my question before handing the money over? I don't believe for a second that your hiring him was contingent on that. I do believe that after you realize it's going to affect your son, you're a good dad and you say, okay, forget it. But that doesn't mean you get all the money back from May until July when you decided that. That's not how it works. I realize you feel like he didn't do anything because you didn't get anything from it. That doesn't mean he didn't do anything. The $375, please return to him. $375 verdict for the plaintiff. The rest of it, you've earned.
Thank you, Your Honor.
Here. This really is.
Mr. DeMont, let me talk to you.
No. I want my paperwork. Where's my paperwork?
Well, Mr. DeMasi does not want to talk to me, that's for sure. He's a little fried right now. What you think about what just happened?
Well, I feel bad for Mr. DeMasi and the decisions that he's made. I wish him all the best, and should he decide that he needs to file another bankruptcy petition or a bankruptcy petition, I think he really does need it. It will benefit him. We're here. There's plenty of other attorneys that'll be glad to do it.
Were you surprised that he sued you?
No, I'm not surprised. People have the right to have their claims evaluated by a court or another arbitral body.
Okay. Well, you had good records. That saved you, right?
Well, I think that the facts of the case saved. Yeah,
Very good.
Thank you, sir.
very much, sir.
Have
Okay.
a pleasant day.
You must sign a few documents on your way out.
Thank you.
Same to you. Harvey, what do you think?
It is painful to do, I know, but you should read a retainer agreement, or at least the key provisions, when you hire a lawyer. It will come back to bite you if you don't. That will do it for this case. Litigants for the next case on the way into the courtroom right now.